नंबर 21A सेक्शन 265A application of the chapter 1. This chapter shall apply in respect of in accused against whom A. The report has been forwarded by the officer in charge of the police station under section 173. 173 aligning therein that in offence appear to have been committed by him other than in offence for which the punishment of death or of imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the 7 year has been 7 year has been provided under the law for the time being in force over B. A magistrate has been cognization of an offence on complaint other than in offence for which the punishment of death or of imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the time being in force, and after examining complaint and witness under section 200 issue the process under the section 204, but does not apply where such offence affect the socio-economic condition of the country or has been committed against a woman or a child below the age of the 14 year below the age of the 14 year below the age of the 14 year। यानी कि पील बारगेनिंग में क्या हुआ है, पील बारगेनिंग यानी कि पील बारगेनिंग 21A 265 एप्लीकेशन ऑफ द चैप्टर दिस चैप्टर शैल अप्लाई इन रिस्पेक्ट ऑफ इन accused against whom the report has been forwarded by the officer in charge of the police station under section 173 aligning therein that in offence appear to have been committed by him other than in offence for which the punishment of death or in imprisonment for life or imprisonment for a term exceeding 7 years has been provided under the law for the time being in force over B. A magistrate has been cognization of in offence on complaint other than in offence for which the punishment of death or of year has been provided under the law for the time being in force, and after examining complaint and witness under section 200 issued by the process under the section 204, but does not apply where such offence affect the socio-economic condition of the country or has been committed against a woman or a child below the age of the 14 year or for the purpose of a subsection 1, the central government shall by notification determining the offence under the law for the time being in force which shall be the offence affecting the socio-economic condition of the country comment. The central government has by SO एक हज़ार 42 डेट 11 जुलाई 2006 डिटरमाइनिंग द ऑफेंस अंडर द फॉलोइंग law for the time being in force which shall be the offence affecting the socio-economic condition of the country for the purpose of the subsection 1 of the section 265 namely Dowry Prohibition Act 1961, Dowry Prohibition Act 1961, 2. The Commission of the Sati Prevention Act 1987, 3rd. The Indecent Representation of Women Indecent Representation of Women Prohibition Act 1986, 4. The Immoral Traffic Prevention Act 1956, 5. The Protection of Women for the Domestic Violence Act 2005, 6. Infant Milk इन्फेंट। 6 हो गया इन्फेंट, द इन्फेंट मिल्क सब्स्टिट्यूट फीडिंग बोतल एंड इन्फेंट फूड रेगुलेशन ऑफ द प्रोडक्शन सप्लाई एंड डिस्ट्रीब्यूशन एक्ट 1992। और 7 प्रोविजन ऑफ द फ्रूट प्रोडक्ट ऑर्डर 1955 इशू अंडर द इसेंशियल सर्विस कमोडिटी एक्ट 1955। और 8 प्रोविजन ऑफ द मीट फूड प्रोडक्ट ऑर्डर 1973 इशू अंडर द इसेंशियल कमोडिटी एक्ट 1955। 9 offense with respect to the animal that find place in schedule 1 and part 2 of the schedule 2 as well as offense related to the altering of boundary of protected area under the wildfile wildfile wildlife protection act 1972। wildlife protection act 1972। 10 the scheduled caste and scheduled tribe prevention of atrocity act 1989। 11 offense mentioned in the protection of the civil right act 1955। और 12 offense listed in section 23 to 28 of the juvenile justice care and protection of the children act 2000। 12 offense listed in section 23 to the 28 of the juvenile justice care and protection of the children act 2000। और उसके बाद 13 द आर्मी एक्ट 1950। 13 द आर्मी एक्ट 1950, द एयरफोर्स एक्ट 1950, द नेवी एक्ट 1957। और 16 ऑफेंस स्पेसिफाइड इन सेक्शन 59 to 81 एंड 83 ऑफ द दिल्ली मेट्रो रेलवे ऑपरेशन एंड मेंटेनेंस एक्ट 2002। और 17 द एक्सप्लोसिव एक्ट 1884। एक्सप्लोसिव एक्ट 1884। एक्सप्लोसिव एक्ट 1884। एक्सप्लोसिव एक्ट 18 offense specified in section 11 to 18 of the cable television network regulation act 1995। और 19 स्केनोमेटोग्राफी एक्ट 1952। स्केनोमेटोग्राफी एक्ट 1952। 265 बी एप्लीकेशन फॉर प्ली बार्गेनिंग application for the plea bargaining application for the plea bargaining, a person accused of an offense may file application for plea bargaining in the court in which such offense is pending for trial, though the application under subsection 1 shall contain a brief description of the case related to which the application is filed, including the offense to which the case related, and shall be complaints by an affidavit sworn by the accused stating therein that he has voluntarily preferred, after understanding the nature and extent of the punishment provided under the law for the offense, the appeal offense and appeal bargaining in this case, and that he has not previously been convicted by a court in case in which he had been charged with the same offense. Third, after receiving the application under subsection 1, the court shall issue notice to the public prosecutor over the complaint of the case, as the case may be, and to the accused to appear on the date fixed for the case. For when the public prosecutor over the complaint of the case has the case may be and accused appear on the date fixed under subsection 3, the court shall examine the accused in camera where the other party in the case case shall not be present to satisfying itself that the accused has filed the application voluntary or where the court is satisfied that the application has been filed by the accused voluntary. It shall provide time to the public prosecutor or the complaint of the case as the case may be and the accused to work out in a mutual satisfactory deposition of the case which may include giving to the victim by the accused the compensation and other expense during the case and thereafter fix the date for further hearing of the case. B. The court find that the application has been filed involuntary by or he has previously has been victed convicted has been convicted by the court in a case in which he had been charged with the same offense. It shall proceed further in accordance with provision of this provision of this code from the stage such application has been filed under the subsection 1 265 सी 265 सी guideline for the mutual satisfactory deposition guideline for mutual guideline for mutual satisfactory deposition in working out a mutual satisfactory deposition under the clause 1 of the subsection 4 of section 265b. The court shall follow the following procedure, namely: a. In a case institute on a police report, the court shall issue notice to the public prosecutor. Court shall issue notice to the public prosecutor, the police officer who has been investigate the case, the accused and the victim of the case to participate in the meeting to work out in a satisfactory deposition of the case. Satisfactory disposition of the case, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by the party participating in the meeting. Full stop. Provided further that the accused, if he so desire he so desire hmm, A. In a case instituted in a police report, the court shall issue notice to the public prosecutor, the police officer who has investigated the case, the accused and victim of the case to be participating in the meeting to work out in a satisfactory disposition of the case. Satisfactory disposition of the case, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by the party participating in the meeting. Provided further that the accused, if he so desire, may participated in such meeting with this pleader if any engaged in the case. Be in a case institute otherwise than on police report, the court shall issue notice to the accused and the victim of the case to participate in the meeting to work out in a satisfactory disposition of the case. Satisfactory disposition of the case हो गया. Satisfactory disposition of the case, provided that it shall be the duty of the court to ensure